appellant.
Thank you. Yes?
Yes, sir. My name is Mwaboeze Nwankwo.
Yes.
My appearance is for the first and second respondents.
Yes.
Yes, sir.
Any other party?
No, my lord.
The third to fifth respondents were this out?
Yes, my lord, they were served.
Third to fifth respondents were served on the 31st.
All right. Well, gentlemen,
Yes, sir.
The judgment in this appeal was written by me, and my name is Luke Ulosodipe, JCA. I happen to be the presiding justice of Owerri Division. And in the panel were my lords Adefokwe Okoje and AA Wambai, JJCA. These judgments started by the normal introduction, the relevant facts captured,
It's not my own person. I want to mix it on.
factored in the judgment, and having done that, the particulars of when the appeal was heard, the issues formulated by the appellant for the determination of the appeal in his brief of argument was set out. Having done that, I stated thus: it is in my considered view clear from the respective cases of the parties as set up in their pleadings, as well as the issues for the determination of the appeal, distilled from the grounds of appeal, that all that has to be determined in the instant appeal is whether or not the lower court was wrong in its finding that the respondent as claimant established a better title to the land in dispute, despite the counterclaim of the appellant in which he too sought title in respect of the same parcel of land. This is against the backdrop that both parties not only claim the ownership of the land in dispute, but also claim that they have respectively been exercising acts of ownership thereon prior to the institution of the instant case. In the light of the above, I do not see the need to dwell separately on the issues formulated by the appellant for the determination of the appeal. This is more so as they dovetail into one another. Having done the needful and reproduced copiously the arguments, it was concluded thus. Flowing from all that has been stated herein before, is that the lower court could not have entered judgment in favor of the appellants, given the fact that the said court rightly found, as it were, that the respondent proved a better title to the land in dispute. The appellant has, in his brief of arguments, argued that the claim for damages for trespass should not have been dismissed by the lower court. He also argued against the propriety of the damages awarded in favor of the respondent for trespass. I must say right away that I see no issue upon which the appellant can be said to have predicated his complaint in respect of the quantum of damages awarded the respondent for the trespass to his land. I will therefore not dwell on this aspect of the submissions of the appellant further. The complaint in respect of the quantum of damages awarded the respondent does not flow from any of the grounds of appeal in the notice of appeal filed by the appellant. In respect of the dismissal of the claim of the appellant for trespass, it is no doubt the correct position of the law that a claim in trespass is granted in possession. However, it would appear that the appellant has forgotten the principle of law that a person in possession cannot successfully maintain an action in trespass against the owner of a parcel of land in the relevant case cited. This being the position of the law, and as it is my finding that the lower court was right to have found that the respondent established a better title to the land in dispute, it follows automatically that the claim of the appellant for trespass could not have been granted by the lower court. Going from all that has been said herein before, is that the lower court rightly entered judgment for the respondent in the instant case, having regard to the legal evidence before it. The said court, in the same vein, correctly dismissed the counterclaim of the appellant, having rightly found that the Did you lose me at any point in time, or did I lose you? No answer. In the final analysis, the instant appeal is grossly unmeritorious and it is dismissed. The judgment of the lower court appealed against is hereby affirmed in its entirety. I award cost in the sum of 200,000 naira in favor of the respondent and against the appellant. My learned brothers, in their respective contributions, agree with the judgment just given. Thank you. efforts will be made to get the judgment ready as soon as possible.
As promised.
It's not.
But open our case.
CAOW 268/2017 between Reverend G.C. Honor.
Isn't so?
Reverend G.C. Honor.
What did you do, man?
The one you did is Mr. Christian.
No, no, no. It's not our case.
What was the appearances?
M. Okori for that pillar.
For Honor or for
For Christian Umwekwe.
I just live there. Gentlemen,
Yes, my
Yes, my
lord.
lord.
Yes, sir.
it appears that the first judgment actually that I held
Yes, sir.
and delivered is CAOW 268/2017.
Yes, my lord.
That is Reverend G.C. Onoha versus Pastor Oyekuchi Emmanuel Azu. So if the appearances in that appeal were not properly recorded, can I just have the appearances?
As God pleases.
Yes, who are the parties there? Is the party present? Are parties present?
Yes.
Who is that? Appellant?
The respondent, my lord, Pastor Azu.
Respondent is present.
Yes, my
Yes.
What of the council appearance?
lord. Humbly, my lord.
Yes.
I am
You should have-
Uzamaka
Uzoamaka,
Ogwadi Uru.
please, they are making the recording.
As God pleases.
Spell your name.
My lord, Uzamaka, Uzoamaka. Ogwadi Uru is spelled Oguadiuru.
Did you appear at the argument of the appeal?
Yes, my lord, I appeared once. Then my principal in office.
No, at the argument of the appeal.
The argument. No, my lord, my principal came in for the
Okay.
argument.
Because if you appear, then your name will be on record.
G.O. Nwokog Square.
My lord,
Okay,
of respondents.
all right.
G.O. Nwokog Square is for the
Yes.
appellant.
Okay, did you hear the judgment just read, or you want me to go by it again?
My lord, I don't know. Honestly, I lost contact with the reading.
Okay, I will just narrate
My lord,
what I've now. Yes?
yes. The concluding aspect of it, my lord.
Okay, just take your time, you will hear.
As God pleases.
All the needful, I hope the Appellant's Council is hearing.
Yes, I'm hearing
The
so
issue-
the network.
Well, there's not, I cannot turn into network.
Yes, sir. Yes, sir.
Yes, sir.
As the court pleases.
Can I become a conductor?
As the court, please.
We have to live with what obtains in the country. The appeal
Yes, sir.
was determined on the issue as to whether the lower court was wrong in finding better title to reside in the respondents. The issues for determination as formulated by the appellants and which issues the respondents adopted were duly set out in the judgment. Having gone through and resolved each of the issues, the court in conclusion stated thus: the court in conclusion stated thus, flowing from all that has been said herein before, is that the lower court rightly entered judgment for the respondent in the instant case, having regard to the legal evidence before it. The said court in the same vein correctly dismissed the counterclaim of the appellant, having rightly found that the respondent established the better title to the land in dispute. Accordingly, all the issues formulated by the appellant for the determination of the instant appeal are resolved against him and in favor of the respondent. In the final analysis, the instant appeal is grossly unmeritorious and it is dismissed. The judgment of the lower court appealed against is hereby affirmed in its entirety. Award cost in the sum of 200,000 naira in favor of the respondent and against the appellant. And I said before that my brothers who sat in the panel with me, that is my Lord Adefope Okoje, JCA, and my Lord A.A. Wambai, JCA, both agree with the decision just delivered. Thank you.
We are most grateful, my Lord.
So the reconstruction has been done.
We're grateful.
Yes, sir. Yes. You want to say something?
No, sir. We are well.
That's all right. If you're not saying anything, let them call the next case.
We are grateful, my Lord.
Yes.
CAOW 237/
We are pleased with the judgment.
between Christian Umekwe, Christian Chibueze, and Donna Chibueze Tasie, Mr. Madabuchi Chibueze. Yes, Mr. FM Boko, Commissioner of Police. My Lord, parties are absent.
Gentlemen, are you with us? Are you with
Lord,
each other?
Yes, ma'am.
we have lost contact.
You have
We have
lost
lost
contact.
contact. Yes, sir. With the visual contact.
Visual, but you have voice contact.
Yes, we have lost the visual contact, sir.
And you don't need to see my face.
As
You
the
know,
court pleases.
You know I'm a human being.
Yes, sir. My claim, of course.
Announce your appearances, please.
May I please, my Lord? I'm
Yes.
CN Wokoria. My
Yes,
appearance is for that appellant, my Lord.
thank you. Yes,
What was the one voice? My name?
yes.
I understand. Yes, I respectfully appear for the first and second respondents, sir.
Yes, thank you.
Yes, sir.
Well, this case deals with enforcement of fundamental rights.
Yes, sir.
I wrote the judgment.
Yes, my lord.
The leading, let us say the leading judgment. It's a case in which the respondents, the first and second respondents, got judgments before the lower court, and the first and second respondents at the lower courts became appellants because they are aggrieved by the decision. All the necessary facts were captured in the judgment. The grounds of the prayer sought in the motion by which the action was commenced set out in the judgment. What the lower court, how the lower court resolved the case was set out in the judgment. The grounds of appeal they were set out in the judgment, and the issues for determination were set out in the judgment. The first issue for determination related to the correctness of the decision of the lower court striking out the further counter affidavit of the appellants. This being an issue of evidence, which if found in favor of the appellants might eventually affect the judgment, was considered first. Having given extensive listening on it, discussion of law, the lower court was found to have struck out the counter affidavit in question because two authorities of this court, one decided by me, another decided in Abuja in the year 2017, were cited in aid of the position of the court. Having done that, on the merit of the case, thus, the last issue for resolution in the instant appeal is the order of perpetual injunction granted by the lower court against the appellants, and third to fifth respondents. The said order reads, it was reproduced. Having highlighted the submissions of the parties before now, I am of the considered view that the argument of the respondents to show that the matter giving rise to this application is not the disputed ownership of the land upon which the respondents are rebuilding is very fanciful and tenuous. The respondents, having regard to the injunctive order they sought in the instant action and which was already executed as it were, and having not presented any fact to show that there was any likelihood of the appellants and the third to fifth respondents repeating the acts for which they have been restrained, in my considered view, were surreptitiously seeking for an order endorsing their supposed ownership of the land on which they were rebuilding their burnt mud house. The fundamental right proceeding is not suited for such a course of action. An order of injunction in the manner in which it was granted by the lower court is not appropriate in the circumstances of the case. And the respondents were being very crafty or mischievous in seeking for the order in question. And this court cannot allow the respondents to pull wool over its eyes as the lower court has allowed them to. This is despite the fact that the said court stated expressly in its judgment that I have carefully gone through the application together with the various affidavits and written addresses. I must tread with caution with regard to the exhibits of the appellants and the first and second respondents and the issues touching on the matter which is before the Court of Appeal. The further affidavit filed by the respondents glaringly show that there is a dispute as to the ownership by the respondents of any part of the Umuebo family land, and that it is in exercise of their alleged right over the land to the exclusion of the appellants that made the said appellant to bring in the police into the matter, and as a consequence of which the respondents were arrested and detained. I am at one with the appellants that a fundamental right proceeding is not to be used to establish ownership of land, even as I also agree that the respondents did not need to establish their ownership of the said land to prove the wrongness of their arrest and detention in respect of the parcel of land which they claim to have possession of. Since I am of the considered view that no matter the angle from which the order of perpetual injunction granted the respondent by the lower court cannot but be said to be surreptitiously connected with the issue of ownership of the land on which the respondents were building, this court cannot allow the same to stand. The said order of perpetual injunction must be struck down, and it is hereby so struck down. Flowing from all that has been said above is that appellant's issue 5 is resolved in their favor. In the final analysis, the instant appeal is not totally devoid of merits. Given the resolution of appellant's issue 5 in their favor, accordingly, the judgment of the lower court appealed against by the appellants is upheld, save that the prayer or relief for an order of perpetual injunction granted the respondents by the lower court is dismissed. I make no order as to cause in the circumstances of the instant appeal. My brothers who were in the panel agree with the judgment just delivered. Thank you.
My Lord, we are grateful.
All right.
My Lord, we are grateful.
Yes, sir.
Yes, the court is grateful too. All right. So you can continue making inquiries online for when the judgment is going to be ready. The clean copies. Clean copies.
As God please.
Yes, sir.
All right. Gentlemen, you have a nice
Yes,
day.
my Lord.
The court will rise.
God.